My second guest to chat about this, Jim DeSimone. He's a civil rights trial lawyer. Jim, welcome. I appreciate you being here. You're out there in Los Angeles, I believe, and first time on my program. So as always, I apologize. So, Jim, tell me what do you think about this cross-exam? You know, you would think this officer is really just a fact witness. He's just kind of laying the groundwork for what happened that day, maybe timeline involved. But defense goes after him pretty strong here.
Well, understandably so. I mean, as a trial lawyer, you always want your first witnesses to set up your case in a way that at the end of those witnesses, the jury's going to think, yes, I'm going for, in this case, the prosecution. Here we have the first witness, surprisingly, is someone who wasn't even aware of the search warrant before it was effectuated or executed here. So you wonder why he's put first when he was there after the fact. In this situation, what is the key point here? Did the officers announce themselves? The Breonna Taylor case that had been brought up, the big fact was this was a no-knock warrant. The police didn't identify themselves, and the claim of self-defense is that much more plausible and actually justified when you don't know who's on the other side of the door in the middle of the night. Here you have a situation where you've got very different situation. Career criminal, he's hiding himself. But what did the police do? I would want the first officer to come up there and say, we knocked, we announced ourselves, they clearly knew we were the police, and he shot and killed that man anyway.
Yeah, and we'll have to see how that plays out. I'm thinking about this guy as a career criminal. Maybe he had other people he would be hiding from. Maybe that makes that part of his claim more credible.